Hello and welcome to this update on the news that the English language requirement is being increased for some UK visas in January 2026. In a nutshell, the UK government has confirmed that new applicants applying for the skilled worker visa or the high potential individual visa or the scale-up route from the 8th of January 2026 are going to have to meet a higher standard of English. That's going from a GCSE equivalent to an A-level equivalent standard. Now, my name's Jill, and in this video, we're going to look in detail at what these immediate changes to the English language requirement are. We're going to look at who's going to be affected, so that's new visa applicants, existing visa holders who will be extending their visa or switching, and we'll also look at the position for dependents. And of course, we'll also consider what the change means for employers recruiting or employing individuals under these routes. Now, before we get started, the usual disclaimer applies. Now, I can explain the rules and the general position in this video, but you shouldn't rely on this as legal advice. If you need advice, book a fixed fee telephone consultation with one of our legal advisors here at DavidsonMorris. You can ask the questions and get the answers tailored to your specific situation. The details are in the description below. Also, take a look at the DavidsonMorris website. It's full of information and resources about UK visas and immigration. Okay, let's dive in. On the 14th of October, the Home Office issued an announcement about changes to the English language requirement. This coincided with an official statement of changes to the immigration rules that covered a wider range of updates. Now, the government issues these statements of changes usually a couple of times a year, and it's basically the official process to update and change the immigration rules and system. So this latest statement of changes on the 14th of October included a change to increase the English language requirement from a GCSE equivalent to an A-level equivalent for anyone applying for a skilled worker visa or a high potential individual visa or a scale-up visa from the 8th of January 2026. So what is the actual uplift in the threshold? To explain, it's best to look at the current position. So at the moment, English language standards are required for only some visa routes, and different levels of English ability are needed for different visas. So if we stick with these work visa routes, currently these visa applicants have to prove their English language ability across reading, writing, speaking, and listening to level B1 of the Common European Framework of Reference for Languages. You'll see that abbreviated to the CEFR. So B1 is broadly equivalent to a GCSE level English. Now, under the revised rules from January 2026, the new standard for these visas is level B2 of the Common European Framework of Reference for Languages. Now, B2 is equivalent to A-level standard. That's a notably higher standard that requires a better knowledge and understanding and use of English. Now, in terms of how you prove this, applicants have to take a test with a secure English language test provider, and these have to be approved by the Home Office. The results of that test will then be checked directly as part of the visa application. Now, currently, there are only 3 visa categories affected at this time, but these are some of the more popular UK work visa routes. So when the new rules come in, those thousands of applicants each year will have to now meet that higher threshold. The government has also indicated that other work routes are likely to follow suit, with a higher threshold coming in at a later date for more types of work visas. So let's look at what the changes mean for new applicants applying under these routes. The higher English standard applies to new visa applications made on or after the 8th of January 2026 under the affected visa routes. So that's the skilled worker, high potential individual and scale-up routes. these applicants will have to be able to speak, read, write and understand English to the B2 level. So anyone applying for one of these visas for the first time or switching into one of these routes will need to meet the B2 standard. If you're applying after the 8th of January and you've already passed the B1 test, you'll no longer qualify unless you retest for the B2 standard. Now, what about existing visa holders? If you already have a UK work visa in one of the affected routes, that's skilled worker, scale-up worker, or the high potential individual route, the new English language rule taking effect on the 8th of January does not automatically apply to you. The higher B2 level will apply only to new applicants from that date. So that's people applying for their visa for the first time or switching into one of these routes. If you already have permission under one of these routes and later apply to extend your visa with the same employer or to renew it on the same route, you'll continue to be assessed at the current B1 level. You won't be asked to meet the higher B2 standard just to extend your stay. However, if you switch into a different visa route after the 8th of January 2026, for example, if you move from the high potential individual or the scale up to the skilled worker visa, you'll need to meet the B2 English requirement as part of that new application. So in practical terms, existing visa holders can carry on as you are for now. You don't need to retake your English test or upgrade your certificate just to extend your visa. But if you plan to switch to a different route after January 2026, you may need to show a higher standard at that stage. Right, let's look at the position for dependents. In terms of dependents of the work visa routes, at this stage, the new rule applies only to main applicants for those work visas. Dependents, so that's spouses, partners and children, are not currently required to meet any English language level when they apply as dependents. So they can continue to apply as before as long as they meet the eligibility criteria under the dependent rules. However, the government has said that this is likely to change and that English language requirements for dependents in both work and study routes will be introduced in a future phase of reforms. So this means it's very likely the dependents will, in time, also need to demonstrate English to a specified level before being granted a visa to join or accompany the main applicant. But for now, no English test is required for dependent applications. Right, what about employers with sponsored workers? How does the new requirement affect them? So employers hiring under the skilled worker or high potential individual or scale-up routes will need to make sure they account for the higher English language standard, usually by updating their internal recruitment processes and compliance documents. Now, for most employers, the higher threshold shouldn't dramatically reduce candidate numbers. Skilled workers in most cases already meet or exceed the higher B2 standard, especially in professional and client-facing roles. But your process and documents need to reflect the change in rules. The Home Office will expect sponsors to be aware of the new level and to have evidence that language level checks were carried out before assigning a certificate of sponsorship. So, your sponsorship compliance procedures should include a specific step to verify the candidates hold a valid English test certificate from an approved provider at the required level. You should also review your recruitment policies and your job adverts and your eligibility criteria so that all references to the English requirement reflect the new B2 standard for applications made on or after the 8th of January 2026. So in particular, you're going to want to look at your recruitment materials and your onboarding guidance. And in workforce planning terms, you may also want to consider how the change affects your recruitment timelines. So candidates who previously passed B1 may now need extra time to prepare and complete the high-level test. So you may need to build that into your hiring schedules to avoid any last-minute refusals or delays. Remember also that for existing sponsored workers, the rule does not apply retrospectively. So anyone extending on the same route can continue under the current B1 requirement. But if they switch to a new visa route after January 2026, they may need to meet the new B2 level. So what next for the English language requirement? So far, the new B2 level applies only to main applicants under the skilled worker, scale-up and high potential individual routes. We know the government intends to broaden the higher English language requirement to a wider range of routes, certainly dependents and also likely other work visas. Possibly family visas could also see the standard change in the future. So it's going to be important to stay informed of the changes and also to be aware that often the new rules come in with little to no notice. So if you are planning a UK application, it may be worth considering speeding up your plans to take advantage of the lower thresholds. Now, if you want advice on your circumstances and what the changes mean for you, your organisation or your own application, get in touch with us at DavidsonMorris, book a fixed fee telephone consultation and get the answers to your questions there and then.